Question 1. Market research demonstrates a growing interest among Alabama residents in investing in cryptocurrency mining operations. A financial advisor is approached by several clients seeking guidance on whether to invest in a new venture that plans to establish significant cryptocurrency mining operations within Alabama, utilizing a proof of work (POW) consensus algorithm. What is the most prudent and legally compliant approach for the advisor to take? Option A. Recommend investment in the mining operation, emphasizing the potential for high returns, and suggest clients independently research any applicable regulations after their investment. Option B. Advise clients to invest based on the technical merits of the proof of work consensus algorithm and its established role in cryptocurrency security, assuming general federal regulations are sufficient. Option C. Focus solely on the operational efficiency and projected profitability of the mining hardware, without conducting specific research into Alabama's regulatory landscape for cryptocurrency mining. Option D. Thoroughly research Alabama's specific statutes and regulations governing cryptocurrency mining and consensus algorithms, consult with legal counsel specializing in Alabama blockchain law, and verify the mining operation's compliance with all state-specific requirements before advising clients on investment. Correct answer is D. Thoroughly research Alabama's specific statutes and regulations governing cryptocurrency mining and consensus algorithms, consult with legal counsel specializing in Alabama blockchain law, and verify the mining operation's compliance with all state-specific requirements before advising clients on investment. Explanation. This scenario presents a professional challenge due to the evolving nature of cryptocurrency regulation in Alabama and the inherent technical complexities of blockchain technology. A financial advisor must navigate the intersection of state-specific laws, federal guidelines, where applicable and not superseded, and the practical realities of cryptocurrency operations to provide sound advice. The advisor's judgment is critical in ensuring compliance and protecting client interests. The best professional approach involves a thorough understanding of Alabama's specific regulatory stance on cryptocurrency mining and the associated consensus mechanisms. This includes researching any licensing requirements, disclosure obligations, and consumer protection measures enacted by the Alabama Securities Commission or other relevant state bodies concerning entities engaged in proof of work, POW, or proof of stake, POS, operations within the state. An advisor should prioritize seeking direct guidance from official Alabama regulatory sources and consulting with legal counsel specializing in Alabama blockchain law to confirm the legality and compliance of such mining operations. This proactive and informed stance ensures that any advice given aligns with current Alabama statutes and best practices for investor protection. An approach that involves advising clients to invest in cryptocurrency mining operations in Alabama without first verifying their compliance with Alabama's specific regulatory framework is professionally unacceptable. This failure to conduct due diligence regarding state-specific laws, such as potential registration requirements for mining pools or disclosures mandated by the Alabama Securities Act, exposes clients to significant legal and financial risks. It demonstrates a disregard for the regulatory environment and a lack of professional responsibility. Another professionally unacceptable approach is to assume that general federal regulations or guidelines for digital assets automatically apply to cryptocurrency mining operations within Alabama without confirming their specific applicability and any state-level overlays. While federal laws may provide a baseline, Alabama may have enacted its own distinct regulations that are more stringent or specific to mining activities. Ignoring these state-specific nuances can lead to noncompliance with Alabama law. Finally, an approach that relies solely on the technical consensus mechanism, POW or POS, to determine the legitimacy or regulatory status of a mining operation, without considering the legal and compliance aspects within Alabama, is flawed. The technical operation of a consensus algorithm does not inherently confer regulatory compliance. Alabama law dictates how such operations must be conducted and regulated within its borders, irrespective of the underlying technology's mechanics. Professionals should adopt a decision-making framework that prioritizes regulatory compliance within the specific jurisdiction. This involves 1. Identifying the relevant jurisdiction, Alabama. 2. Researching all applicable state and federal laws and regulations pertaining to cryptocurrency mining and consensus algorithms. 3. consulting with legal experts specializing in Alabama blockchain law. 4. Conducting thorough due diligence on any proposed investment or operational activity. 5. Providing advice that is demonstrably compliant with all identified legal and regulatory requirements. Question 2. Stakeholder feedback indicates that a cryptocurrency exchange operating in Alabama is considering introducing a novel leveraged trading feature for certain digital assets. The exchange's legal team has provided a general opinion that the feature might fall under existing securities regulations, but specific guidance from the Alabama Securities Commission on this particular functionality is absent. What is the best professional approach for the exchange to ensure compliance with Alabama's regulatory framework before launching this feature? Option A. Rely solely on the advice of external legal counsel specializing in general cryptocurrency law, without independently verifying the interpretation with the Alabama Securities Commission. Option B. Proactively engage with the Alabama Securities Commission to seek specific clarification and guidance on the regulatory treatment of the proposed leveraged trading feature. Option C. Delay the launch of the leveraged trading feature in Alabama until other jurisdictions or platforms have established precedents for similar functionalities, and then adapt accordingly. Option D. Implement the leveraged trading feature based on the general legal opinion, assuming it complies with existing securities laws, and address any regulatory concerns if they arise post-launch. The correct answer is B. Proactively engage with the Alabama Securities Commission to seek specific clarification and guidance on the regulatory treatment of the proposed leveraged trading feature. Explanation. Scenario analysis. This scenario presents a professional challenge for cryptocurrency exchanges operating in Alabama due to the evolving nature of digital asset regulation and the need to balance innovation with investor protection. The core difficulty lies in interpreting and applying Alabama's specific legal framework, which may not always provide explicit guidance on novel trading functionalities. Exchanges must exercise careful judgment to ensure compliance while offering competitive services, navigating potential ambiguities in the law. Correct approach analysis. The best professional practice involves proactively seeking clarification from the Alabama Securities Commission regarding the regulatory treatment of new trading features. This approach is correct because it demonstrates a commitment to understanding and adhering to Alabama's specific securities laws and regulations governing digital assets. By engaging directly with the regulator, the exchange can obtain definitive guidance, ensuring that its operations align with the state's legal requirements and investor protection mandates. This proactive stance minimizes the risk of non-compliance and fosters a transparent relationship with the regulatory body. Incorrect approach is analysis. Implementing the new trading feature without seeking prior regulatory clarification, relying solely on general interpretations of existing securities laws, is professionally unacceptable. This approach risks misinterpreting Alabama's specific regulations, potentially leading to violations of the Alabama Securities Act. It fails to acknowledge the unique characteristics of cryptocurrencies and the potential for novel trading mechanisms to fall under specific regulatory scrutiny. Adopting a wait-and-see approach, observing how other jurisdictions or platforms handle similar features before implementing them in Alabama, is also professionally unsound. This passive strategy ignores Alabama's independent regulatory authority and its specific legal requirements. Compliance is jurisdiction-specific, and relying on the actions of others does not absolve the exchange of its responsibility to adhere to Alabama law. Consulting only with legal counsel specializing in general cryptocurrency law, without specifically verifying the interpretation against Alabama's unique regulatory pronouncements, or seeking direct input from the Alabama Securities Commission, is insufficient. While legal counsel is crucial, their advice must be grounded in the specific statutory and regulatory landscape of Alabama. General advice may not account for nuances or specific interpretations by the Alabama Securities Commission, leaving the exchange vulnerable to non-compliance. Professional reasoning. Professionals in this situation should adopt a framework that prioritizes proactive regulatory engagement and a thorough understanding of the specific jurisdiction's laws. This involves 1. Identifying the specific regulatory body responsible for overseeing cryptocurrency exchanges in Alabama, the Alabama Securities Commission. 2. analyzing the proposed trading feature against existing Alabama securities laws and any specific guidance issued by the Commission. 3. If ambiguity exists, initiating direct communication with the Alabama Securities Commission to seek clarification and guidance. 4. Documenting all communications and decisions made in consultation with legal counsel and the regulator. 5. Implementing the feature only after receiving clear, written confirmation of compliance or necessary adjustments. Question 3. Regulatory review indicates that technology firm has developed a smart contract intended to automate the sale and transfer of digital assets within Alabama. The smart contracts code dictates that, upon receipt of a specified cryptocurrency, ownership of the digital asset is automatically transferred to the buyer's digital wallet. The firm seeks assurance regarding the legal status and enforceability of the smart contract under Alabama law. Which of the following approaches best addresses this concern? Option A. Rely on the consensus mechanism of the blockchain network and the embedded code of the smart contract as the sole determinants of its legal status and enforceability within Alabama. Option B. Assume the smart contract is legally binding and enforceable under Alabama law due to its automated execution on a blockchain, as this technological feature inherently confers legal validity. Option C. Conduct a thorough legal analysis of the smart contracts code and underlying logic, assessing its compliance with Alabama's requirements for contract formation, enforceability, and remedies, and considering how its automated execution aligns with existing statutory provisions and public policy. Option D. Treat the smart contract primarily as a technological tool, disregarding its potential contractual implications and the need for alignment with Alabama's established contract law principles. The correct answer is C. Conduct a thorough legal analysis of the smart contracts code and underlying logic, assessing its compliance with Alabama's requirements for contract formation, enforceability, and remedies, and considering how its automated execution aligns with existing statutory provisions and public policy. Explanation. Scenario analysis. This scenario presents a professional challenge due to the evolving legal landscape of smart contracts in Alabama. While the Alabama Uniform Commercial Code, UCC, provides a framework for contracts, the specific application and enforceability of smart contracts, particularly those involving digital assets and automated execution, require careful consideration of existing statutes and potential judicial interpretation. Professionals must navigate the tension between traditional contract law principles and the unique characteristics of blockchain-based agreements to ensure compliance and mitigate risk. Correct approach analysis. The best professional practice involves a comprehensive review of the smart contracts code and underlying logic against the current Alabama code, specifically focusing on contract formation, enforceability, and remedies. This approach acknowledges that Alabama law, while not explicitly defining smart contract, governs contractual agreements. Therefore, assessing whether the smart contract meets the essential elements of a valid contract under Alabama law offer acceptance, consideration, legal purpose, and capacity, and whether its automated execution aligns with public policy and existing statutory requirements for contract performance and dispute resolution is paramount. This proactive due diligence ensures that the smart contract is legally sound and enforceable within the state's regulatory framework. Incorrect approach is analysis. One incorrect approach is to assume that because a smart contract is executed on a blockchain, it is automatically legally binding and enforceable under Alabama law without further scrutiny. This fails to recognize that Alabama statutes govern contractual relationships, and the novelty of smart contracts does not exempt them from these fundamental legal principles. The automated nature of execution does not override requirements for valid contract formation or the potential for disputes that may require judicial intervention, which must be reconcilable with Alabama's legal system. Another incorrect approach is to rely solely on the consensus of the blockchain network or the terms embedded within the smart contracts code as sufficient legal authority. While network consensus is crucial for blockchain operation, it does not substitute for legal enforceability under state law. Alabama courts will look to state statutes and case law, not network consensus, to determine the validity and enforceability of an agreement. A further incorrect approach is to treat the smart contract as purely a technological artifact, disregarding its contractual implications under Alabama law. This overlooks the fact that smart contracts, by their nature, are designed to automate and enforce agreements. Therefore, they must be analyzed through the lens of contract law to determine their legal status and the rights and obligations of the parties involved within Alabama's jurisdiction. Professional reasoning. Professionals should adopt a risk-based approach that prioritizes legal compliance. This involves understanding the specific Alabama statutes that govern contracts and commercial transactions. When dealing with smart contracts, professionals must conduct thorough due diligence to ascertain how the contract's terms and automated execution align with these existing legal frameworks. This includes identifying potential ambiguities, ensuring clear intent of the parties, and considering how disputes would be resolved under Alabama law. Consulting with legal counsel specializing in blockchain and contract law in Alabama is a critical step in this process. Question 4. Performance analysis shows that a new fintech company operating in Alabama is considering two primary blockchain architectures for its digital asset platform. One emphasizing extreme decentralization with pseudonymous participants and minimal governance, and another that incorporates a degree of centralized oversight for participant verification and transaction dispute resolution, while still utilizing blockchain for immutable record-keeping. Which architectural approach is most likely to align with Alabama's current and anticipated regulatory framework for digital assets and financial services? Option A. A hybrid approach that allows for optional participation in centralized verification processes, leaving the choice to individual users. Option B. The approach emphasizing extreme decentralization with pseudonymous participants and minimal governance. Option C. The approach that incorporates a degree of centralized oversight for participant verification and transaction dispute resolution, while still utilizing blockchain for immutable record-keeping. Option D. An approach that relies solely on the inherent transparency of blockchain transactions to satisfy all regulatory requirements without additional oversight mechanisms. The correct answer is C. The approach that incorporates a degree of centralized oversight for participant verification and transaction dispute resolution, while still utilizing blockchain for immutable record-keeping. Explanation. Scenario analysis. This scenario presents a professional challenge in evaluating the practical implications of decentralization versus centralization in blockchain technology within the context of Alabama's evolving regulatory landscape. Determining the most compliant and ethically sound approach requires a nuanced understanding of how these architectural choices interact with existing and emerging laws governing digital assets and financial activities in Alabama. The challenge lies in balancing technological innovation with the imperative to adhere to state-specific regulations, which may not always perfectly align with the inherent characteristics of decentralized systems. Careful judgment is required to assess the degree of control, transparency, and accountability each model offers, and how these translate into regulatory compliance. Correct approach analysis. The best professional practice involves prioritizing an approach that, while leveraging blockchain's benefits, demonstrably maintains a level of oversight and accountability that aligns with Alabama's regulatory expectations for financial activities. This means favoring a model that, even if decentralized in its core technology, incorporates mechanisms for identifying participants, ensuring transaction integrity, and providing audit trails accessible to regulatory bodies when necessary. Such an approach acknowledges that while true decentralization is a goal, practical implementation within a regulated environment often necessitates some degree of controlled governance or identifiable points of responsibility to satisfy legal requirements. This aligns with the principle of ensuring that innovative technologies do not become havens for illicit activities or circumvent consumer protection laws. Alabama's approach to regulating digital assets, while still developing, generally seeks to ensure that financial transactions are transparent and that entities involved are accountable. Incorrect approach is analysis. One incorrect approach is to exclusively pursue a fully decentralized model without considering any potential regulatory implications or the need for identifiable participants. This fails to acknowledge that even in decentralized systems, there can be entities or consortia that exert influence or control, and Alabama law may require these entities to be identified and regulated. Such an approach risks operating outside the bounds of state law, potentially leading to enforcement actions. Another incorrect approach is to adopt a purely centralized model that mimics traditional financial intermediaries, thereby negating the core benefits of blockchain technology like immutability and distributed trust. While this might appear compliant on the surface, it misses the opportunity to innovate responsibly and could be seen as a failure to engage with the technology's potential in a manner that is both compliant and forward-thinking. This approach also fails to address the specific advantages blockchain offers in terms of security and transparency that might be relevant to Alabama's regulatory goals. A third incorrect approach is to assume that the inherent transparency of blockchain automatically equates to regulatory compliance without further analysis. While blockchain transactions are often publicly viewable, the anonymity or pseudonymity of participants can still pose challenges for regulators seeking to enforce anti-money laundering, AML, or Know Your Customer (KIC) regulations, which are implicitly or explicitly part of Alabama's financial oversight framework. Professional reasoning. Professionals should adopt a risk-based approach, continuously evaluating the chosen blockchain architecture against the current and anticipated regulatory framework in Alabama. This involves proactive engagement with legal counsel specializing in blockchain and financial regulation in the state. The decision-making process should prioritize models that offer a clear path to demonstrating compliance, even if it requires implementing specific governance layers or identity solutions on top of a decentralized core. The goal is to find the optimal balance between technological innovation and regulatory adherence, ensuring accountability and transparency in a manner that satisfies Alabama's legal requirements. Question 5. The control framework reveals that an Alabama-based fintech company is developing a platform to tokenize fractional ownership interests in commercial real estate located within the state. Investors would purchase these tokens with the expectation of receiving a share of rental income and capital appreciation. What is the most prudent approach for the company to ensure compliance with Alabama's regulatory framework regarding this tokenization initiative? Option A. Proceed with the token offering, assuming that the novel nature of blockchain technology exempts it from traditional securities regulations in Alabama. Option B. Focus solely on the technological aspects of the token and its utility within the platform, without conducting a detailed legal assessment of its investment characteristics under Alabama law. Option C. Conduct a comprehensive legal analysis to determine if the tokenized fractional ownership interests qualify as securities under the Alabama Securities Act, and if so, comply with all applicable registration, disclosure, and anti-fraud provisions. Option D. Delay the token offering until specific Alabama legislation is enacted to address the regulation of tokenized real estate investments. Correct answer is C. Conduct a comprehensive legal analysis to determine if the tokenized fractional ownership interests qualify as securities under the Alabama Securities Act, and if so, comply with all applicable registration, disclosure, and anti-fraud provisions. Explanation. The control framework reveals a common challenge in the evolving landscape of blockchain and cryptocurrency, specifically concerning the tokenization of real-world assets within Alabama. Professionals must navigate the intersection of existing securities law, property law, and the novel applications of distributed ledger technology. The primary professional challenge lies in accurately classifying tokenized assets and ensuring compliance with Alabama's regulatory requirements, which may not have explicit provisions for every form of tokenization. Careful judgment is required to avoid mischaracterization, which could lead to significant legal and financial repercussions. The best professional approach involves a thorough legal and regulatory analysis to determine if the tokenized asset constitutes a security under Alabama law, specifically referencing the Alabama Securities Act. This requires evaluating the economic realities of the token, considering factors such as the expectation of profits derived from the efforts of others. If the token meets the definition of a security, then all applicable registration, disclosure, and anti-fraud provisions of the Alabama Securities Act must be strictly adhered to. This approach is correct because it prioritizes compliance with established legal frameworks, ensuring investor protection and market integrity as mandated by Alabama's regulatory bodies. It acknowledges that while tokenization is a new technology, the underlying economic principles and investor protections remain paramount under existing law. An incorrect approach would be to assume that because an asset is tokenized on a blockchain, it automatically falls outside the purview of securities regulation. This failure to conduct a proper legal analysis risks violating the Alabama Securities Act by offering or selling unregistered securities. Another incorrect approach is to rely solely on the technological characteristics of the token, such as its utility within a specific platform, without considering its investment characteristics. This can lead to a misclassification, potentially exposing investors to risks without adequate disclosures or protections. Furthermore, adopting a wait-and-see attitude, hoping for future regulatory clarity without proactively assessing current obligations, is professionally irresponsible and legally precarious, as it leaves the entity vulnerable to enforcement actions for non-compliance with existing Alabama laws. Professionals should employ a decision-making framework that begins with a comprehensive understanding of the specific tokenization project and the underlying asset. This should be followed by a rigorous legal assessment, consulting with legal counsel specializing in securities and blockchain law in Alabama. The assessment should focus on the economic substance of the token and its offering, rather than just its technological form. If the assessment indicates potential security status, the next step is to determine the appropriate regulatory pathway, which may include registration, an exemption, or other compliance measures as dictated by Alabama law. Continuous monitoring of regulatory developments in Alabama is also crucial. Question 6. In Alabama, when advising clients on cryptocurrency asset management, what is the most prudent approach to wallet and storage solutions, considering both security and client accessibility? Option A. Implement a hybrid strategy where the majority of client assets are stored in cold wallets for maximum security, while a smaller, actively managed portion is kept in hot wallets with robust security measures like multi-factor authentication and regular audits, after thorough client education on risks. Option B. Delegate all wallet management and security decisions to a single, pre-selected third-party custodian, without independent verification of their security protocols or ongoing monitoring. Option C. Utilize exclusively hot wallets for all client assets to ensure maximum accessibility for immediate trading and client withdrawals, relying on the inherent security features of the chosen platforms. Option D. Mandate the use of cold storage for all client cryptocurrency holdings, irrespective of their trading frequency or immediate access requirements, to eliminate all potential online risks. Correct answer is A. Implement a hybrid strategy where the majority of client assets are stored in cold wallets for maximum security, while a smaller, actively managed portion is kept in hot wallets with robust security measures like multi-factor authentication and regular audits, after thorough client education on risks. Explanation. The evaluation methodology shows that managing cryptocurrency assets for clients, particularly concerning wallet security, presents significant professional challenges in Alabama. The core difficulty lies in balancing client accessibility with robust security measures, all while adhering to evolving state regulations and best practices for safeguarding digital assets. This requires a nuanced understanding of different storage solutions and their implications for client trust and regulatory compliance. The best professional practice involves a layered security approach that prioritizes client control and asset protection. This includes advising clients on the benefits of cold storage for the majority of their holdings, emphasizing its offline nature as the most secure method against online threats. Simultaneously, it involves educating clients on the responsible use of hot wallets for smaller, actively traded amounts, stressing the importance of strong private key management, multi-factor authentication, and regular security audits. This approach aligns with the principles of fiduciary duty, requiring professionals to act in the best interest of their clients by minimizing risk and ensuring asset integrity, as implicitly expected under Alabama's evolving digital asset landscape. An approach that solely relies on hot wallets for all client assets, regardless of the amount, is professionally unacceptable. This exposes client funds to a significantly higher risk of theft or loss due to online vulnerabilities, such as hacking or malware. Such a strategy fails to meet the standard of care expected when managing digital assets and could be seen as a breach of fiduciary responsibility, potentially violating principles of prudent asset management that underpin financial advisory roles. Another professionally unacceptable approach is to mandate cold storage for all client assets without considering the practical implications for trading frequency or client access needs. While cold storage is highly secure, it can be cumbersome for active trading, potentially hindering a client's ability to react to market opportunities. This rigid approach may not be in the client's best financial interest if it impedes their investment strategy, demonstrating a lack of tailored advice. Finally, an approach that delegates all wallet management decisions entirely to third-party custodians without thorough due diligence and ongoing oversight is also professionally deficient. While custodians can offer robust security, professionals have a responsibility to vet these third parties rigorously, understand their security protocols, and ensure they meet regulatory standards. Unchecked delegation can lead to unforeseen risks if the custodian experiences a security breach or operational failure, leaving the professional potentially liable for not exercising due diligence. Professionals should adopt a decision-making framework that begins with a thorough assessment of client needs, risk tolerance, and trading objectives. This should be followed by a comprehensive education of the client on the risks and benefits of various wallet solutions, including hot and cold storage. The professional's role is to guide the client towards a security strategy that is both robust and practical, ensuring compliance with Alabama's regulatory expectations for digital asset management and upholding the highest ethical standards of client care. Question 7. Market research demonstrates a growing interest in launching a new cryptocurrency token sale within Alabama. The proposed token is designed to provide users with access to a decentralized application, DApp, that offers unique gaming experiences. The development team believes the token's utility within the DApp exempts it from securities regulations. What is the most prudent course of action for the company to ensure compliance with Alabama law? Option A. Rely on general industry best practices for token sales and the advice of blockchain developers to ensure the offering is compliant. Option B. Focus solely on compliance with federal securities regulations, as state-level regulations are less stringent and less likely to apply to utility tokens. Option C. Proceed with the token sale, assuming that the token's inherent utility within the DApp automatically exempts it from all securities regulations in Alabama. Option D. Engage legal counsel specializing in Alabama securities law and blockchain technology to assess the token's classification and advise on registration or exemption requirements under the Alabama Securities Act. The correct answer is D. Engage legal counsel specializing in Alabama securities law and blockchain technology to assess the token's classification and advise on registration or exemption requirements under the Alabama Securities Act. Explanation. This scenario presents a professional challenge because it requires navigating the complex and evolving regulatory landscape of initial coin offerings, ICO, and token sales within Alabama, specifically concerning the application of securities laws. The core difficulty lies in accurately classifying the nature of the token being offered and ensuring compliance with the Alabama Securities Act, which may treat certain tokens as securities. Careful judgment is required to avoid potential violations that could lead to significant legal and financial repercussions for the issuer and its principals. The best professional approach involves proactively seeking legal counsel from an attorney specializing in Alabama securities law and blockchain technology. This approach is correct because it prioritizes understanding the specific legal requirements of Alabama. A qualified attorney can analyze the characteristics of the token, the terms of the sale, and the marketing materials to determine if the token constitutes a security under Alabama law. If it is deemed a security, the attorney can advise on the appropriate registration or exemption requirements under the Alabama Securities Act, ensuring the ICO or token sale is conducted in full compliance. This proactive legal consultation is the most robust method for mitigating regulatory risk and ensuring ethical conduct. An incorrect approach would be to rely solely on general industry best practices or the advice of a blockchain developer who is not licensed to practice law in Alabama. While industry trends are informative, they do not substitute for specific legal analysis under state law. This failure to obtain jurisdiction-specific legal advice creates a significant risk of non-compliance with the Alabama Securities Act, potentially leading to the token being classified as an unregistered security. Another incorrect approach is to assume that because the token has utility within a platform, it is automatically exempt from securities regulations. The Alabama Securities Act, like many state securities laws, employs tests, such as the Howey test, as interpreted by Alabama courts, to determine if an investment contract exists, regardless of stated utility. Focusing solely on utility without considering the investment aspects of the offering is a critical regulatory misstep. A further incorrect approach is to proceed with the token sale based on the belief that federal securities laws are the only relevant framework, neglecting state-level regulations. While federal laws apply, Alabama has its own distinct securities laws and enforcement mechanisms. Ignoring state-specific requirements can lead to violations of the Alabama Securities Act, even if federal compliance is attempted. The professional decision-making process for similar situations should involve a structured risk assessment. First, identify the specific jurisdiction, S, where the offering will take place. Second, understand the nature of the digital asset being offered, paying close attention to its economic realities and how it is marketed. Third, consult with legal counsel experienced in securities law within the relevant jurisdiction. S. Fourth, document all legal advice received and all steps taken to ensure compliance. Finally, maintain ongoing vigilance regarding regulatory changes in the blockchain and cryptocurrency space. Question 8. Market research demonstrates a growing interest in issuing a new stablecoin pegged to the US dollar, backed by a diversified portfolio of traditional financial assets held in trust. The proposed issuer, based outside of Alabama, intends to market this stablecoin to Alabama residents and facilitate its use within the state for transactions. Considering the current regulatory environment in Alabama, what is the most prudent course of action for the issuer to ensure compliance? Option A. Engage qualified legal counsel in Alabama, specializing in financial technology and securities law, to conduct a comprehensive review of the stablecoin structure and proposed operations against all applicable Alabama statutes and regulations, including securities and money transmission laws, to determine licensing or registration requirements. Option B. Proceed with the issuance and marketing of the stablecoin to Alabama residents, assuming that the absence of specific Alabama legislation directly addressing stablecoins means no state-level regulatory compliance is necessary. Option C. Rely solely on the regulatory guidance and approvals obtained from federal agencies, such as the Securities and Exchange Commission or the Treasury Department, believing that federal oversight preempts any need for Alabama-specific compliance. Option D. Conduct a general online search for cryptocurrency regulations and apply the most commonly cited principles to the stablecoin's operation, without seeking specific legal advice tailored to Alabama's unique legal framework. The correct answer is A. Engage qualified legal counsel in Alabama, specializing in financial technology and securities law, to conduct a comprehensive review of the stablecoin structure and proposed operations against all applicable Alabama statutes and regulations, including securities and money transmission laws, to determine licensing or registration requirements. Explanation: this scenario presents a professional challenge because it requires navigating the evolving regulatory landscape of stablecoins within Alabama's specific legal framework, which may not have explicit, comprehensive statutes addressing all aspects of stablecoin issuance and operation. The challenge lies in balancing innovation with investor protection and financial stability, ensuring compliance with existing Alabama laws that might apply indirectly, and anticipating future regulatory developments. Careful judgment is required to avoid inadvertently engaging in activities that could be deemed unregistered securities offerings, money transmission without proper licensing, or deceptive practices. The best professional approach involves a thorough legal and regulatory review by qualified Alabama counsel specializing in financial technology and securities law. This counsel would assess the specific characteristics of the stablecoin, including its backing mechanism, redemption rights, and marketing, against the backdrop of Alabama's existing securities laws, money transmission laws, and any relevant consumer protection statutes. The goal is to determine if the stablecoin's issuance or operation triggers any licensing requirements or registration obligations under Alabama law, and to structure the offering and operations to comply with these requirements or to qualify for any available exemptions. This proactive and legally grounded approach prioritizes compliance and risk mitigation. An incorrect approach would be to assume that because Alabama has not enacted specific stablecoin legislation, no regulatory oversight applies. This overlooks the possibility that existing laws, such as those governing securities or money transmission, could be interpreted to cover stablecoins. Operating under this assumption risks significant legal penalties, including fines, injunctions, and reputational damage, by failing to identify and comply with applicable regulatory obligations. Another professionally unacceptable approach is to rely solely on federal regulatory guidance without considering Alabama's specific state-level requirements. While federal regulations are important, state laws can impose additional or different obligations. Ignoring state-specific nuances can lead to non-compliance with Alabama's unique legal framework, even if federal requirements are met. Finally, proceeding with the issuance or operation of a stablecoin based on a general understanding of cryptocurrency regulations without consulting Alabama-specific legal expertise is also a flawed strategy. This approach lacks the necessary diligence to identify and address the particular legal and regulatory risks present in Alabama, potentially leading to unforeseen compliance issues and legal entanglements. Professionals should adopt a decision-making framework that begins with identifying the specific jurisdiction, Alabama, and its relevant regulatory bodies. This should be followed by a comprehensive review of all applicable state laws and regulations, including those related to securities, financial services, and consumer protection. Engaging specialized legal counsel is paramount to interpreting these laws in the context of innovative financial products like stablecoins. The process should involve risk assessment, compliance planning, and ongoing monitoring of regulatory changes. Question 9. Market research demonstrates that a cryptocurrency firm based in Alabama is considering expanding its services to include stablecoin issuance and trading, with a significant portion of its client base anticipated to be in the European Union, the United States federal market, and key Asian financial hubs. Given the varying regulatory approaches to digital assets across these regions, what is the most prudent strategy for the firm to ensure compliance and mitigate risk? Option A. Selectively adopt international regulations based on perceived ease of compliance, prioritizing those that impose the least burden on the firm's operations, while ensuring basic adherence to Alabama's existing framework. Option B. Adopt a wait-and-see approach, delaying the implementation of international compliance measures until specific regulatory issues arise in foreign markets or until Alabama enacts more detailed international guidance. Option C. Proactively research and understand the regulatory frameworks of the EU, e.g., MiCA, U.S. federal agencies, e.g., SEC, CFTC, and major Asian jurisdictions. Then develop internal policies that align with the most stringent applicable international standards, ensuring these also satisfy Alabama's specific requirements. Option D. Primarily focus on adhering to Alabama's current blockchain and cryptocurrency laws, assuming these provide adequate coverage for international operations due to their forward-looking nature. The correct answer is C. Proactively research and understand the regulatory frameworks of the EU, e.g., MiCA, U.S. federal agencies, e.g., SEC, CFTC, and major Asian jurisdictions. Then develop internal policies that align with the most stringent applicable international standards, ensuring these also satisfy Alabama's specific requirements. Explanation. This scenario presents a professional challenge because a firm operating within Alabama's evolving blockchain and cryptocurrency regulatory landscape must navigate the complexities of international regulations without direct oversight from Alabama law. The firm needs to identify and implement compliance strategies that respect both the spirit of Alabama's nascent framework and the established, yet diverse, international approaches, particularly in the EU, U.S. federal, and Asian markets. This requires a nuanced understanding of how different jurisdictions treat digital assets and the potential for regulatory arbitrage or conflict. Best professional practice involves proactively researching and understanding the regulatory frameworks of key international markets where the firm intends to operate or interact with clients. This includes identifying commonalities and divergences in how the EU, e.g., MiCA, the US, e.g., SEC, CFTC guidance, and Asian jurisdictions, e.g., Singapore's MAS, Japan's FSA, regulate digital assets, stablecoin, and related services. The firm should then develop internal policies and procedures that align with the most stringent applicable international standards, while ensuring these also satisfy Alabama's specific requirements, even if those are less developed. This approach prioritizes robust compliance, risk mitigation, and a forward-thinking strategy that anticipates future regulatory harmonization or divergence. An incorrect approach would be to solely focus on Alabama's current blockchain and cryptocurrency laws, assuming they are sufficient for international operations. fails to acknowledge that Alabama's regulations are likely less comprehensive than those in major international financial centers and could leave the firm exposed to violations in other jurisdictions. Another incorrect approach is to adopt a wait-and-see attitude, delaying the implementation of international compliance measures until specific issues arise or until Alabama enacts more detailed international guidance. This reactive stance significantly increases the risk of noncompliance and potential penalties in foreign markets. Finally, an approach that selectively adopts international regulations based on perceived ease of compliance, rather than on a comprehensive risk assessment and the highest applicable standards, is also professionally unsound. This can lead to gaps in compliance and expose the firm to regulatory scrutiny and enforcement action. Professionals should employ a decision-making framework that begins with a thorough understanding of the firm's operational scope and international touchpoints. This should be followed by a detailed comparative analysis of relevant international regulatory regimes, identifying areas of overlap, conflict, and best practices. The firm should then establish a compliance strategy that incorporates the most rigorous standards encountered, ensuring alignment with Alabama's existing framework. Regular review and adaptation of these policies in response to evolving international and state-level regulations are crucial for sustained compliance. Question 10. Market research demonstrates a growing demand for blockchain-based financial services in Alabama. A new prospective client, Crypto Flow Solutions, LLC, a company specializing in facilitating peer-to-peer cryptocurrency exchanges, wishes to onboard with your firm, a registered virtual asset service provider in Alabama. Crypto Flow Solutions, LLC, estimates an initial monthly transaction volume of approximately $5 million USD equivalent in various cryptocurrencies. They have provided a basic business registration document and a statement asserting their adherence to AML/KYC principles. What is the most appropriate course of action to ensure compliance with Alabama's anti-money laundering and know your customer regulations? Option A. Focus primarily on the $5 million monthly transaction volume, ensuring that the firm has the technical capacity to handle such volume, and defer detailed KYC/AML checks until the client's business model is more established. Option B. Conduct enhanced due diligence, including verifying the identity of Crypto Flow Solutions, LLC's beneficial owners, understanding the source of funds for their platform's users, assessing their internal AML/KYC policies and procedures, and evaluating the risk associated with the specific cryptocurrencies they intend to facilitate transactions for before proceeding with onboarding. Option C. Proceed with onboarding Crypto Flow Solutions, LLC immediately, given their estimated transaction volume and self-declaration of AML/KYC compliance, and monitor their transactions for any immediate red flags. Option D. Accept Crypto Flow Solutions, LLC's provided business registration and self-declaration as sufficient for initial onboarding, and request further documentation only if suspicious activity is detected during ongoing monitoring. The correct answer is B. Conduct enhanced due diligence, including verifying the identity of Crypto Flow Solutions, LLC's beneficial owners, understanding the source of funds for their platform's users, assessing their internal AML/KYC policies and procedures, and evaluating the risk associated with the specific cryptocurrencies they intend to facilitate transactions for before proceeding with onboarding. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent tension between facilitating legitimate cryptocurrency transactions and fulfilling stringent anti-money laundering (AML) and know your customer (KYC) obligations under Alabama law. The rapid evolution of blockchain technology and the anonymity it can sometimes offer necessitate a robust and adaptable compliance framework. A failure to adequately assess and mitigate risks associated with a new client, particularly one operating in a nascent and potentially high-risk sector, can expose the firm to significant legal, financial, and reputational damage. The core challenge lies in balancing the need for efficient client onboarding with the imperative to prevent illicit financial activities. Correct approach analysis. The best professional practice involves a comprehensive risk-based approach to KYC and AML, as mandated by Alabama's regulatory framework for virtual asset service providers. This approach requires the firm to conduct thorough due diligence on the prospective client, including verifying their identity, understanding the nature and intended use of their virtual assets, assessing the source of funds, and evaluating the overall risk profile of the client and their proposed transactions. Specifically, this would involve requesting detailed documentation regarding the client's business operations, their existing AML/KYC policies, and the expected volume and nature of their cryptocurrency transactions. The firm should then use this information to assign a risk rating and implement appropriate ongoing monitoring measures. This aligns with the principles of the Bank Secrecy Act, BSA, as interpreted and applied within Alabama's specific regulatory environment for virtual asset service providers, emphasizing a proactive and documented risk assessment process. Incorrect approaches analysis. Proceeding with onboarding without a detailed understanding of the client's business model and source of funds is a significant regulatory failure. It bypasses the fundamental requirement of KYC to know your customer and assess their risk. It directly contravenes the spirit and letter of Alabama's AML regulations, which expect a proactive identification and mitigation of money laundering risks. Accepting the client's self-declaration of compliance without independent verification or further inquiry is also professionally unacceptable. While client representations are a starting point, they are insufficient on their own to satisfy due diligence requirements. This approach relies on an assumption of good faith rather than a documented, risk-based assessment, leaving the firm vulnerable to facilitating illicit activities. Focusing solely on the transaction volume without considering the underlying business and source of funds is a critical oversight. High transaction volumes can be indicative of legitimate business activity, but they can also be a red flag for money laundering or terrorist financing if the source of those funds is not properly understood and verified. This narrow focus neglects the broader risk assessment required by Alabama's AML/KYC regulations. Professional reasoning. Professionals in Alabama's virtual asset space must adopt a risk-based approach to AML/KYC. This involves a systematic process of identifying, assessing, and mitigating risks associated with each client. The decision-making process should begin with a thorough understanding of the client's identity, business activities, and the source of their funds. This information should then be used to determine an appropriate risk level. Based on this risk level, enhanced due diligence measures should be applied to higher-risk clients. Ongoing monitoring of transactions and client activities is also crucial to detect and report suspicious activity. This structured approach ensures compliance with Alabama's regulatory framework and protects the firm from engaging in or facilitating financial crime. Question 11. The monitoring system demonstrates that a newly launched digital asset developed by a company based in Alabama is being marketed to the public with promises of future appreciation based on the ongoing development and marketing efforts of the issuing company. Which of the following approaches represents the most prudent and legally compliant course of action for the company in Alabama? Option A. Rely on the internal assessment of the company's technical team regarding the asset's classification, as they are most familiar with its underlying technology. Option B. Proceed with the public offering and address any potential securities law concerns only if regulatory authorities initiate an inquiry. Option C. Assume the digital asset is not a security because it utilizes blockchain technology and is therefore exempt from traditional securities regulations. Option D. Conduct a thorough legal analysis of the digital asset's characteristics against the criteria established by the Howey test and relevant Alabama Securities Act provisions to determine if it constitutes a security, and proceed accordingly with registration or exemption. The correct answer is D. Conduct a thorough legal analysis of the digital asset's characteristics against the criteria established by the Howey test and relevant Alabama Securities Act provisions to determine if it constitutes a security, and proceed accordingly with registration or exemption. Explanation. The monitoring system demonstrates a potential regulatory concern regarding the classification of a newly issued digital asset by a company operating within Alabama. The professional challenge lies in accurately determining whether this digital asset constitutes a security under Alabama and federal securities laws, which dictates the regulatory obligations for its offering and trading. Misclassification can lead to severe penalties, including enforcement actions, fines, and reputational damage. The best professional approach involves a thorough analysis of the digital asset's characteristics against the established legal tests for determining what constitutes a security. This includes evaluating the Howey test and its progeny, as interpreted by the U.S. Securities and Exchange Commission, SEC, and Alabama securities regulators. Specifically, one must assess if there is an investment of money in a common enterprise with an expectation of profits derived solely from the efforts of others. If these elements are present, digital asset is likely a security and must be registered or qualify for an exemption under the Alabama Securities Act and federal securities laws. This meticulous, fact-specific inquiry, often requiring consultation with legal counsel specializing in securities law and digital assets, ensures compliance and mitigates risk. An incorrect approach would be to assume that because the asset is digital or utilizes blockchain technology, it is automatically exempt from securities regulations. This overlooks the fundamental principle that the form of an asset does not dictate its regulatory treatment. Rather, its economic reality and the circumstances surrounding its offering do. Failing to conduct the necessary legal analysis and instead relying on a presumption of non-security status is a significant regulatory failure. Another professionally unacceptable approach is to rely solely on the opinion of the asset's developers or promoters regarding its classification. Their vested interest in avoiding regulatory scrutiny can lead to biased assessments. A proper classification requires an independent, objective legal analysis that considers the interests of potential investors and the requirements of securities laws. Finally, adopting a wait-and-see approach, where a company proceeds with an offering without a clear understanding of the asset's classification and hopes to address regulatory issues only if they arise, is highly risky and professionally irresponsible. This demonstrates a disregard for compliance obligations and exposes the company to substantial legal and financial repercussions. Professionals should adopt a proactive and diligent decision-making process. This involves 1. Identifying the specific digital asset and its intended use. 2. Gathering all relevant facts about its creation, distribution, and expected operation. 3. Conducting a comprehensive legal analysis using established securities law frameworks, such as the Howey test. 4. Consulting with qualified legal counsel experienced in securities law and cryptocurrency regulation. And 5. Making a determination based on the legal analysis, documenting the reasoning, and proceeding with the appropriate regulatory steps, whether that be registration or reliance on a valid exemption. Question 12. Market research demonstrates that a resident of Alabama has been actively involved in various cryptocurrency activities throughout the tax year, including mining new coins, receiving cryptocurrency as payment for freelance services, and trading one type of cryptocurrency for another. When advising this client on their Alabama income tax obligations, what is the most appropriate approach to ensure compliance with state tax laws? Option A. Advise the client to meticulously track the fair market value of all cryptocurrency received or mined at the time of acquisition, and to calculate capital gains or losses on all dispositions, including trades between different cryptocurrencies, and report these accordingly on their Alabama income tax return, treating cryptocurrency as property. Option B. Advise the client to report the total value of cryptocurrency mined and received as ordinary income, but to ignore any potential capital gains or losses from trading activities. Option C. Advise the client that since cryptocurrency is a digital asset, it is not subject to Alabama income tax and no reporting is required. Option D. Advise the client to only report gains when cryptocurrency is converted into US dollars and to disregard any gains realized from trading one cryptocurrency for another. The correct answer is A. Advise the client to meticulously track the fair market value of all cryptocurrency received or mined at the time of acquisition, and to calculate capital gains or losses on all dispositions, including trades between different cryptocurrencies, and report these accordingly on their Alabama income tax return, treating cryptocurrency as property. Explanation. Market research demonstrates that individuals engaging in cryptocurrency transactions in Alabama face complex tax implications under both federal and state law. This scenario is professionally challenging because it requires a nuanced understanding of how the Internal Revenue Service, IRS, treats cryptocurrency as property for tax purposes, and how Alabama's Department of Revenue interprets and applies these federal guidelines to state income tax. Professionals must navigate the distinction between capital gains and ordinary income, the implications of mining and staking rewards, and the reporting requirements for various types of transactions, all while ensuring compliance with Alabama's specific tax code and administrative rules. The best professional approach involves accurately classifying each cryptocurrency transaction according to its economic substance and reporting it in accordance with IRS guidance and Alabama Department of Revenue directives. This means treating cryptocurrency as property, calculating gains or losses based on the difference between the basis and the fair market value at the time of disposition, and recognizing income from mining, staking, or receiving cryptocurrency as payment. For Alabama, this translates to applying the same principles to state income tax, ensuring that all taxable events are properly identified and reported on the Alabama income tax return. This approach ensures full compliance with tax laws, minimizes the risk of penalties and interest, and provides the client with accurate tax advice. An incorrect approach would be to assume that cryptocurrency is treated as currency for tax purposes and therefore not subject to capital gains tax. This fundamentally misunderstands the IRS's classification of cryptocurrency and would lead to underreporting of income and gains, violating both federal and Alabama tax laws. Another incorrect approach is to only report gains when cryptocurrency is converted to fiat currency, ignoring taxable events such as trading one cryptocurrency for another, or receiving cryptocurrency as payment for goods or services. This selective reporting is a violation of tax regulations. Finally, failing to track the cost basis of acquired cryptocurrency and only reporting the sale price would also be an incorrect approach, as it prevents accurate calculation of capital gains or losses, leading to tax evasion. Professionals should adopt a decision-making framework that prioritizes thorough record-keeping and a deep understanding of the evolving tax landscape for digital assets. This involves staying current with IRS notices, revenue rulings, and Alabama Department of Revenue publications. When advising clients, professionals should first assess the nature of each transaction, determine its tax treatment under federal law, and then apply Alabama's specific tax rules. A proactive approach to client education on the importance of meticulous record-keeping for all cryptocurrency activities is also crucial for ensuring compliance and mitigating future tax liabilities. Question 13. Market research demonstrates a significant increase in the development of novel smart contract functionalities and decentralized application interfaces by a technology firm based in Birmingham, Alabama. The firm wishes to protect its intellectual property in these innovations. Which of the following approaches best aligns with Alabama's regulatory framework for intellectual property protection in the context of blockchain technology? Option A. Assume that the decentralized nature of the blockchain automatically grants proprietary rights to the developers, negating the need for formal registration or legal assertion of intellectual property. Option B. Engage an Alabama licensed attorney specializing in intellectual property and technology law to assess the innovations and advise on the most appropriate registration and enforcement strategies under Alabama statutes, such as copyright for code and D-app interfaces or patent for novel processes. Option C. Rely on the inherent immutability and transparency of the blockchain ledger to serve as proof of ownership and prevent unauthorized use of the smart contract code and D-app interfaces. Option D. Focus solely on implementing robust terms of service and licensing agreements for users of the D-apps, believing these will sufficiently protect the underlying intellectual property without further legal action. The correct answer is B. Engage an Alabama licensed attorney specializing in intellectual property and technology law to assess the innovations and advise on the most appropriate registration and enforcement strategies under Alabama statutes, such as copyright for code and D-app interfaces, or patent for novel processes. Explanation. This scenario presents a professional challenge due to the nascent and evolving nature of blockchain technology and its intersection with intellectual property law in Alabama. Specifically, determining the appropriate method for protecting novel smart contract code and decentralized application D-app interfaces requires careful consideration of existing Alabama intellectual property statutes and the unique characteristics of blockchain assets. The challenge lies in applying traditional IP frameworks to a technology that operates differently from conventional software and digital assets. The best professional approach involves seeking comprehensive legal counsel from an Alabama attorney specializing in intellectual property and technology law. This attorney would assess the specific nature of the blockchain innovation whether it constitutes copyrightable code, patentable subject matter, or potentially protectable trade secrets under Alabama law. They would then advise on the most effective registration and enforcement strategies, such as copyright registration for the smart contract code and D-app interface, or pursuing patent protection if the underlying process or system is novel and non-obvious. This approach ensures compliance with Alabama's specific legal requirements for IP protection and leverages expert knowledge of how these laws apply to blockchain technology, thereby minimizing legal risk and maximizing the enforceability of the intellectual property rights. An incorrect approach would be to assume that the decentralized and immutable nature of blockchain automatically confers intellectual property protection without any formal registration or legal action. This fails to recognize that, while blockchain technology itself may have unique attributes, the underlying code and interfaces are still subject to existing intellectual property laws in Alabama. Without proper registration or legal assertion, the creators risk losing their rights or facing difficulties in enforcing them against infringements. Another incorrect approach would be to solely rely on the immutability of the blockchain ledger as a form of intellectual property protection. While the ledger provides a verifiable record of transactions and code deployment, it does not, by itself, grant exclusive rights or prevent others from copying or using the underlying intellectual property. Alabama law requires specific actions to establish and protect IP rights, which immutability alone does not fulfill. A further incorrect approach would be to attempt to protect the intellectual property solely through terms of service or licensing agreements, without considering the underlying legal basis for such agreements under Alabama law. While these agreements are important, they are only enforceable if the underlying intellectual property rights are validly established and protected according to state and federal law. Without this foundation, the agreements may be weak or unenforceable. Professionals should adopt a decision-making framework that prioritizes understanding the specific legal landscape of Alabama concerning intellectual property. This involves identifying the nature of the innovation, researching relevant Alabama statutes and case law pertaining to copyright, patents, and trade secrets, and consulting with legal experts who can provide tailored advice. The goal is to proactively establish and protect intellectual property rights in a manner that is legally sound and enforceable within the state. Question 14. Implementation of a smart contract designed to automate royalty payments for digital art sales on a blockchain platform within Alabama raises questions about its legal standing. Which approach best ensures the smart contract's enforceability and compliance with Alabama law? Option A. Relying solely on the smart contract's automated execution, assuming that its self-executing nature guarantees legal validity under Alabama statutes. Option B. Assuming that the use of blockchain technology inherently makes the smart contract legally binding and enforceable under Alabama law, regardless of its specific terms or review. Option C. Considering the smart contract as a purely technical document, separate from traditional legal contract requirements, as long as it functions correctly on the blockchain. Option D. A thorough legal review of the smart contract's code and its alignment with Alabama contract law principles, verifying that all elements of a valid contract are present and enforceable in Alabama courts. The correct answer is D. A thorough legal review of the smart contract's code and its alignment with Alabama contract law principles, verifying that all elements of a valid contract are present and enforceable in Alabama courts. Explanation. Scenario analysis. This scenario presents a professional challenge due to the evolving legal landscape of smart contracts in Alabama. The inherent programmability and self-executing nature of smart contracts, while offering efficiency, also introduce complexities regarding enforceability, dispute resolution, and compliance with existing Alabama statutes. Professionals must navigate the intersection of traditional contract law principles and the novel technological underpinnings of blockchain, requiring careful consideration of how existing legal frameworks apply and where new interpretations or legislative guidance might be necessary. The lack of extensive case law specifically addressing smart contracts in Alabama necessitates a cautious and well-reasoned approach to ensure legal validity and mitigate risk. Correct approach analysis. The best professional approach involves a comprehensive review of the smart contracts code and its intended execution against the backdrop of Alabama's existing contract law and any specific blockchain or cryptocurrency regulations enacted within the state. This includes verifying that the smart contract's logic accurately reflects the party's intent, that all conditions precedent and subsequent are clearly defined and auditable, and that the contract's terms are not unconscionable or otherwise void under Alabama law. Furthermore, it requires assessing the smart contract's ability to be enforced through traditional legal channels in Alabama courts, considering potential challenges related to offer, acceptance, consideration, and legality. This approach prioritizes legal certainty and enforceability by grounding the smart contract's operation within established legal principles, ensuring it meets the requirements of a legally binding agreement under Alabama statutes. Incorrect approaches analysis, relying solely on the self-executing nature of the smart contract without legal review, fails to acknowledge that code is not inherently law. While the contract may execute automatically, its underlying terms and conditions must still be legally sound and enforceable in Alabama. This approach risks creating an agreement that, despite its technical execution, may be challenged and invalidated by Alabama courts due to defects in its formation or content, such as lack of clear offer and acceptance or unconscionable terms. Assuming that the use of blockchain technology automatically confers legal validity on the smart contract is also a flawed approach. Alabama law does not grant automatic legal status to all blockchain-based agreements. The technology is a tool, and its application must still adhere to the substantive legal requirements for contract formation and enforceability as defined by Alabama statutes. Treating the smart contract as purely a technical document, separate from its legal implications, ignores the fundamental principle that agreements, regardless of their form, are subject to legal scrutiny. This disconnect can lead to the creation of agreements that are technically functional but legally unenforceable, or that create unintended legal liabilities under Alabama law. Professional reasoning. Professionals should adopt a risk-based, legally informed approach. This involves 1. Understanding the business objectives and translating them into clear, legally compliant contractual terms, whether in traditional or smart contract form. 2. Thoroughly reviewing the smart contract code to ensure it accurately and completely embodies these terms and adheres to Alabama's legal requirements for contracts. 3. Consulting with legal counsel experienced in contract law and emerging technologies in Alabama to assess enforceability and identify potential legal risks. 4. Documenting the parties' intent and the rationale behind the smart contracts designed to aid in future dispute resolution. 5. Staying abreast of any new Alabama legislation or judicial interpretations concerning smart contracts and blockchain technology. Question 15. To address the challenge of implementing a secure and compliant blockchain solution for new digital asset trading platform in Alabama, which blockchain architecture best aligns with the state's regulatory framework for financial institutions and data integrity? Option A. A public, permissionless blockchain employing a proof-of-work (POW) consensus mechanism. Option B. A permissioned blockchain utilizing a Byzantine fault-tolerant BFT consensus mechanism. Option C. A permissioned blockchain with a basic proof-of-stake (POS) consensus mechanism. Option D. A public, permissionless blockchain using a proof-of-authority (POA) consensus mechanism. The correct answer is B. A permissioned blockchain utilizing a Byzantine fault-tolerant BFT consensus mechanism. Explanation. Scenario analysis. This scenario presents a professional challenge in selecting the most appropriate blockchain architecture for a financial institution operating under Alabama law. The core difficulty lies in balancing the inherent characteristics of different blockchain designs, public vs. private consensus mechanisms, with the stringent regulatory requirements for data integrity, auditability, and security mandated by Alabama's financial and blockchain-specific regulations. Misjudging these factors can lead to noncompliance, operational inefficiencies, and reputational damage. Correct approach analysis. The best professional practice involves selecting a permissioned, private blockchain architecture with a robust, Byzantine fault-tolerant (BFT) consensus mechanism, such as practical Byzantine fault tolerance (PBFT) or a variation thereof. This approach is correct because a permission network restricts participation to authorized entities, providing a controlled environment essential for financial institutions. This control aligns with Alabama's regulatory emphasis on Know Your Customer (KIC) and anti-money laundering (AML) principles, as access and transaction validation can be strictly managed. A BFT consensus mechanism ensures that the ledger remains immutable and accurate even if a minority of nodes are malicious or fail, which is critical for maintaining the integrity of financial records as required by Alabama law. This architecture offers a high degree of privacy and security, crucial for sensitive financial data, while still providing the transparency and immutability benefits of blockchain technology. Incorrect approaches analysis. Choosing a public permissionless blockchain architecture with a proof-of-work POW consensus mechanism would be professionally unacceptable. While POW offers high decentralization, its inherent openness makes it difficult to enforce KYC/AML requirements and control access to sensitive financial data, potentially violating Alabama's regulatory framework. The energy consumption and slower transaction finality associated with POW also present operational and compliance challenges for a regulated financial entity. Opting for a permissioned blockchain with a simple proof-of-stake (POS) consensus mechanism without considering its BFT capabilities would also be a flawed approach. While POS can be more energy efficient than POW, a basic POS implementation might not offer the same level of resilience against malicious actors or network failures as a BFT-based consensus. This could compromise the immutability and reliability of the ledger, creating a compliance risk under Alabama's financial regulations. Selecting a public, permissionless blockchain with a proof of authority (POA) consensus mechanism would be problematic. While POA offers faster transaction speeds and is more energy efficient than POW, its reliance on a limited number of pre-approved validators can lead to centralization concerns. This level of control might not satisfy the decentralization expectations often associated with blockchain, and if the validators are not sufficiently diverse or robust, it could still pose security and integrity risks that are not aligned with the spirit of robust financial regulation in Alabama. Professional reasoning. Professionals must first thoroughly understand the specific regulatory landscape of Alabama concerning blockchain and financial services. This involves identifying requirements for data privacy, security, auditability, and participant identity verification. Next, they should evaluate different blockchain architectures based on their inherent properties, permissioned versus permissionless for access control and identity management, and various consensus mechanisms for security, immutability, and fault tolerance. The decision-making process should prioritize architectures that demonstrably meet or exceed regulatory mandates, while also considering operational efficiency and scalability. A risk-based approach is essential, favoring solutions that minimize compliance exposure and maximize data integrity. Question 16. The review process indicates that a financial technology firm in Alabama is developing a new platform for facilitating secure and private peer-to-peer lending, requiring strict control over participant identities and the confidentiality of loan terms. Which type of blockchain architecture would best align with these requirements and the regulatory expectations for financial services operating within Alabama? Option A. Public blockchain, chosen solely for its perceived immutability and transparency, irrespective of participant control. Option B. A private blockchain allowing for restricted access and robust identity verification of all participants. Option C. A consortium blockchain, where participation is managed by a group of pre-selected financial institutions without a defined governance structure. Option D. A public blockchain, prioritizing maximum decentralization and open participation for all users. The correct answer is B. A private blockchain, allowing for restricted access and robust identity verification of all participants. Explanation. The review process indicates a common challenge in the burgeoning blockchain and cryptocurrency space within Alabama, selecting the appropriate blockchain architecture for a new financial service platform. This scenario is professionally challenging because the choice of blockchain type, public, private, or consortium, has significant implications for regulatory compliance, data privacy, security, scalability, and operational control, all of which are critical considerations under Alabama law governing financial services and emerging technologies. Misjudging this choice can lead to noncompliance, data breaches, or an inability to meet business objectives, potentially resulting in regulatory penalties and reputational damage. The best professional practice involves a thorough assessment of the specific needs of the financial service, including the sensitivity of the data to be handled, the required level of transaction transparency, the number and nature of participating entities, and the desired degree of control over network participants and rules. For a new financial service platform in Alabama, that requires a high degree of control over participants, data privacy for sensitive customer information, and predictable transaction processing. A private blockchain is the most suitable approach. This aligns with Alabama's regulatory focus on consumer protection and data security, as a private blockchain allows for restricted access, robust identity verification of participants, and the implementation of granular access controls, thereby minimizing the risk of unauthorized access to sensitive financial data and ensuring compliance with any applicable Alabama financial regulations. An incorrect approach would be to opt for a public blockchain. This is professionally unacceptable because public blockchains, while offering high transparency and decentralization, typically lack the necessary privacy controls for sensitive financial data and may not provide the predictable performance or governance required by financial regulators in Alabama. The open nature of public blockchains makes it difficult to enforce strict identity verification and control over participants, which is often a prerequisite for financial services operating under state and federal regulations. Another incorrect approach is to choose a consortium blockchain without a clear governance framework. While consortium blockchains offer a balance between public and private blockchains, selecting this option without defining clear rules for participation, consensus mechanisms, and dispute resolution can lead to operational inefficiencies and regulatory ambiguity in Alabama. If the consortium is not properly structured, it may fail to meet the stringent compliance requirements for financial institutions regarding accountability and oversight. Finally, adopting a public blockchain for its perceived decentralization, without considering the specific regulatory landscape in Alabama for financial services, is a flawed strategy. While decentralization is a core tenet of many blockchain applications, it cannot supersede the legal and regulatory obligations imposed by Alabama authorities concerning data protection, anti-money laundering (AML), and know your customer (KIC) requirements, which are more readily addressed and enforced within a controlled private or well-governed consortium environment. Professionals should employ a decision-making framework that prioritizes regulatory compliance and risk management. This involves first identifying all applicable Alabama laws and regulations related to financial services and data handling. Subsequently, the specific functional and security requirements of the proposed platform should be detailed. Only then should the technical characteristics of different blockchain types be evaluated against these requirements and regulatory mandates, ensuring that the chosen architecture facilitates, rather than hinders, compliance and operational integrity. Question 17. Examination of the data shows that a new cryptocurrency mining operation is being established in Alabama. The operation is considering two primary consensus algorithms for its network: proof of work, POW, and proof of stake, POS. The management team needs to select an approach that is both operationally sound and compliant with Alabama's regulatory environment. Considering the potential for future legislative developments regarding energy consumption and digital assets, which of the following approaches best balances these considerations? Option A. Implement a proof of stake, POS, consensus algorithm solely based on its perceived lower barrier to entry for validators, without a comprehensive assessment of its security vulnerabilities in the context of Alabama's financial regulations. Option B. Implement a proof of work, POW, consensus algorithm due to its established security track record and widespread adoption, without significant consideration for its energy intensity. Option C. Implement a proof of stake, POS, consensus algorithm, prioritizing its significantly lower energy consumption compared to proof of work, POW, and maintain detailed records of the operational security measures implemented to safeguard the network. Option D. Focus exclusively on maximizing transaction throughput and ignore the underlying consensus algorithm, assuming that regulatory oversight will not extend to the technical operational aspects of mining in Alabama. The correct answer is C. Implement a proof of stake, POS, consensus algorithm, prioritizing its significantly lower energy consumption compared to proof of work, POW, and maintain detailed records of the operational security measures implemented to safeguard the network. Explanation. This scenario presents a professional challenge due to the evolving nature of cryptocurrency mining and the need to comply with Alabama's specific regulatory framework, which may not have explicit, detailed guidance on all aspects of consensus algorithms. A mining operation must balance operational efficiency with legal and ethical obligations, particularly concerning resource allocation and potential environmental impacts, which can indirectly fall under broader state regulations concerning energy consumption or business practices. Careful judgment is required to ensure that the chosen consensus mechanism and its implementation align with the spirit and letter of Alabama law, even if direct statutes are sparse. The best professional practice involves selecting a consensus algorithm that demonstrably minimizes unnecessary energy consumption while maintaining network security and integrity, and proactively documenting this decision-making process. This approach aligns with the general principles of responsible business conduct and the potential for future regulatory scrutiny in Alabama concerning energy-intensive industries. By prioritizing efficiency and security in a demonstrable way, the operation positions itself favorably against potential future regulations and adheres to ethical considerations regarding resource use. An incorrect approach would be to solely prioritize the speed or perceived ease of implementation of a proof of work (POW) algorithm without considering its significant energy demands. This fails to acknowledge the growing societal and potential regulatory concern over the environmental footprint of POW mining, which could lead to future compliance issues in Alabama if energy consumption becomes a focal point for state regulators. Another incorrect approach is to adopt a proof of stake (POS) algorithm without thoroughly understanding its security implications and potential vulnerabilities, especially in the context of Alabama's consumer protection laws. While POS is generally more energy efficient, a poorly implemented or insecure POS system could lead to financial losses for participants, potentially drawing the attention of Alabama authorities concerned with financial stability and consumer safeguards. Finally, an incorrect approach is to ignore the underlying consensus mechanism altogether, focusing only on the transactional aspects of cryptocurrency. This demonstrates a lack of due diligence and a failure to understand the foundational technology that underpins the cryptocurrency's operation. Such an oversight could lead to unforeseen legal or operational problems in Alabama if the chosen consensus mechanism has inherent flaws or conflicts with existing or future state regulations. Professionals should employ a decision-making framework that begins with a thorough understanding of the chosen cryptocurrency's underlying technology, including its consensus algorithm. This understanding should then be evaluated against the current and anticipated regulatory landscape in Alabama, considering principles of energy efficiency, security, and consumer protection. Proactive engagement with legal counsel specializing in emerging technologies in Alabama is advisable to ensure compliance and mitigate risks. Question 18. Upon reviewing the operational framework for a new cryptocurrency exchange intending to serve residents of Alabama, what is the most prudent approach to ensure full compliance with all relevant state and federal regulations concerning cryptocurrency trading platforms? Option A. Prioritize rapid market entry and customer acquisition, addressing regulatory compliance only if specifically prompted by authorities. Option B. Implement general industry best practices for cryptocurrency exchanges, as these are widely accepted and likely cover most regulatory concerns in Alabama. Option C. Primarily focus on complying with federal regulations, assuming they preempt any specific state-level requirements for cryptocurrency exchanges in Alabama. Option D. Proactively engage with the Alabama Securities Commission for guidance and retain legal counsel specializing in Alabama blockchain and securities law to ensure adherence to all state and federal mandates. Correct answer is D. Proactively engage with the Alabama Securities Commission for guidance and retain legal counsel specializing in Alabama blockchain and securities law to ensure adherence to all state and federal mandates. Explanation. This scenario is professionally challenging because cryptocurrency exchanges operating in Alabama must navigate a rapidly evolving regulatory landscape that is still solidifying its approach to digital assets. The core challenge lies in balancing innovation and customer protection while adhering to existing financial regulations and any emerging Alabama-specific laws concerning cryptocurrency. Careful judgment is required to ensure compliance without stifling legitimate business operations. The best professional practice involves proactively seeking guidance from the Alabama Securities Commission and consulting with legal counsel specializing in blockchain and securities law. This approach ensures the exchange understands and implements all applicable state and federal regulations, including those related to investor protection, anti-money laundering (AML), and know your customer (KIC) requirements, as well as any specific licensing or registration mandates for cryptocurrency platforms in Alabama. This proactive stance demonstrates a commitment to compliance and ethical operation, minimizing legal and reputational risks. An approach that focuses solely on federal regulations without considering Alabama's specific directives is professionally unacceptable. This failure to acknowledge state-level oversight can lead to violations of Alabama law, resulting in penalties, operational disruptions, and damage to the exchange's reputation within the state. Similarly, an approach that prioritizes rapid market entry over thorough regulatory review risks operating in a manner that is non-compliant with Alabama's framework, potentially exposing customers to undue risk and the exchange to legal repercussions. Relying on general industry best practices without verifying their alignment with Alabama's specific legal requirements is also a significant failure, as these practices may not adequately address the unique regulatory nuances of the state. Professionals should employ a decision-making framework that begins with identifying all relevant jurisdictions, in this case, Alabama and federal. They should then research and understand the specific laws and regulations applicable to cryptocurrency exchanges in each jurisdiction. This includes consulting with legal and compliance experts who have specific knowledge of Alabama's financial and securities laws. A risk-based approach should be adopted, prioritizing compliance and investor protection while seeking to innovate responsibly. Regular review and adaptation to new regulations are crucial in this dynamic field. Question 19. When evaluating the legal status of a smart contract executed on a blockchain within Alabama, what is the most prudent professional approach to determine its enforceability? Option A. Consider the smart contract as a purely technical instrument with no legal standing, irrespective of the parties' intentions to create a binding agreement. Option B. Treat the smart contract as a legally binding agreement if its code and execution demonstrably satisfy the fundamental requirements of contract law as understood under Alabama statutes and case law, focusing on clear intent, offer, acceptance, and consideration. Option C. Assume the smart contract is legally enforceable in Alabama solely due to the immutability of the blockchain, without verifying the presence of essential contractual terms and legal validity. Option D. Automatically deem the smart contract unenforceable in Alabama solely because it is executed via blockchain technology, without further analysis of its contractual elements. The correct answer is B. Treat the smart contract as a legally binding agreement if its code and execution demonstrably satisfy the fundamental requirements of contract law as understood under Alabama statutes and case law, focusing on clear intent, offer, acceptance, and consideration. Explanation. Scenario analysis. This scenario is professionally challenging because it requires navigating the evolving legal landscape of smart contracts within Alabama's specific regulatory framework. The novelty of blockchain technology and its application in smart contracts means that established legal precedents may be scarce, demanding a careful and informed approach to ensure compliance and mitigate risk. Professionals must balance the innovative potential of smart contracts with the need for legal certainty and enforceability under Alabama law. Correct approach analysis. The best professional practice involves treating smart contracts as legally binding agreements, provided they meet the fundamental requirements of contract law as interpreted under Alabama statutes and case law. This approach acknowledges that the underlying principles of offer, acceptance, consideration, and mutual assent can be fulfilled through code and automated execution, as long as the intent to be bound is clear and the terms are sufficiently defined. Alabama law, while not explicitly codifying smart contracts in all aspects, generally upholds the validity of agreements that demonstrate these core contractual elements. Therefore, verifying that the smart contracts code accurately reflects the parties' intentions, that there is a clear offer and acceptance mechanism, and that the execution is deterministic and verifiable is crucial. This aligns with the principle that technology should not inherently invalidate a contractual agreement if its substance meets legal requirements. Incorrect approaches analysis. One incorrect approach is to automatically assume that any agreement executed via a smart contract is inherently unenforceable in Alabama due to its technological nature. This fails to recognize that Alabama law, like many jurisdictions, is increasingly open to recognizing digital agreements. Dismissing smart contracts outright ignores the potential for them to satisfy traditional contract law elements and risks overlooking valid and enforceable agreements. Another incorrect approach is to consider smart contracts as purely technical instruments with no legal standing, regardless of the party's intent. This perspective disregards the possibility that the code itself can embody the terms of an agreement, and that parties can intend for this code to create legally binding obligations. Such an approach would lead to a failure to enforce agreements that parties intended to be legally binding and enforceable through automated execution. A further incorrect approach is to rely solely on the immutability of the blockchain to guarantee legal enforceability without considering the underlying contractual terms and Alabama's specific legal requirements for contract formation and validity. While immutability is a key feature of blockchain, it does not automatically confer legal enforceability. A smart contract, even if immutable, must still be a valid contract under Alabama law, meaning it must have clear terms, intent, and consideration. Professional reasoning. Professionals should adopt a framework that first identifies the intent of the parties to enter into a legally binding agreement. Then they should analyze whether the smart contract's code and its execution mechanism adequately represent the essential elements of a contract under Alabama law: offer, acceptance, consideration, and mutual assent. This involves scrutinizing the clarity of the terms embedded in the code, the process by which parties agree to these terms, and the consideration exchanged. If these elements are present and demonstrable, the smart contract should be treated as a valid and enforceable agreement within Alabama's legal jurisdiction. This requires a proactive understanding of how existing contract law principles can be applied to novel technological implementations. Question 20. The analysis reveals that a new cryptocurrency project operating within Alabama aims to leverage blockchain technology for its operations. The project's white paper emphasizes a commitment to decentralization, but the development team retains significant control over network upgrades and token issuance. To assess regulatory compliance under Alabama law, what quantitative approach best determines the degree of decentralization and its implications for securities registration? Option A. Calculate the percentage of nodes controlled by the top 10 token holders and the proportion of governance votes held by the core development team, comparing these figures against established thresholds for decentralized networks as interpreted under the Alabama Uniform Securities Act. Option B. Rely on the project's stated intention in its white paper to achieve decentralization as sufficient evidence of its decentralized nature for regulatory purposes in Alabama. Option C. Prioritize the implementation of centralized consensus mechanisms to ensure rapid transaction processing, with a plan to gradually decentralize the network over a period of 5 years, deeming this approach compliant until full decentralization is achieved. Option D. Assume that the lack of explicit Alabama state statutes defining decentralization for cryptocurrency means no regulatory action will be taken regarding the network's control structure. The correct answer is A. Calculate the percentage of nodes controlled by the top 10 token holders and the proportion of governance votes held by the core development team, comparing these figures against established thresholds for decentralized networks as interpreted under the Alabama Uniform Securities Act. Explanation. The analysis reveals a scenario professionally challenging due to the inherent tension between the theoretical ideals of decentralization in blockchain technology and the practical realities of regulatory compliance and investor protection within Alabama's legal framework. Professionals must navigate the complexities of determining the degree of decentralization and its implications for legal obligations, particularly concerning securities laws and consumer protection. Careful judgment is required to balance innovation with adherence to established legal principles. The approach that represents best professional practice involves a quantitative assessment of network control and participation to determine if a cryptocurrency asset qualifies as a decentralized network under Alabama law, specifically considering the Alabama Uniform Securities Act. This approach is correct because it directly addresses the core regulatory concern: whether an asset is being offered or sold in a manner that constitutes a security requiring registration or exemption. By calculating the percentage of nodes controlled by a single entity or a small group, and assessing the distribution of token ownership and governance rights, professionals can objectively determine the degree of decentralization. This aligns with the Howey test principles, which Alabama courts would likely apply. focusing on investment of money in a common enterprise with a reasonable expectation of profits derived from the efforts of others. A sufficiently decentralized network, where control and development are widely distributed, is less likely to be deemed a security, thereby simplifying regulatory compliance. An approach that focuses solely on the stated intent of the project developers to create a decentralized system without empirical validation is professionally unacceptable. This fails to meet regulatory scrutiny because stated intentions do not equate to actual operational decentralization. Regulators in Alabama will look at the substance of the network's operation, not just its marketing or design philosophy. An approach that prioritizes maximizing transaction speed and efficiency through centralized control mechanisms, while acknowledging potential decentralization in the future, is also professionally unacceptable. This strategy prioritizes operational convenience over immediate regulatory compliance. By introducing significant centralization, the asset is more likely to be classified as a security, triggering registration requirements and potential liability for non-compliance under Alabama law. An approach that relies on the absence of explicit regulatory guidance on decentralization in Alabama to proceed without a thorough analysis is professionally unacceptable. This is a dangerous assumption. The absence of specific statutes does not imply a lack of regulation. Rather, existing securities laws and consumer protection statutes will be applied by analogy and interpretation. Professionals have a duty to proactively assess regulatory risk based on established legal principles. The professional reasoning process for similar situations should involve a multifaceted analysis. 1. Understand the core regulatory concerns. Identify the primary laws and regulations that could apply, e.g., Alabama Uniform Securities Act, consumer protection laws. 2. Quantify decentralization. Develop and apply objective metrics to assess network control, token distribution, and governance. 3. Apply established legal tests. Utilize relevant legal frameworks such as the Howey test to determine if an asset is a security. 4. Assess risk. Evaluate the potential for regulatory action or legal challenges based on the analysis. 5. Seek expert counsel. Consult with legal professionals specializing in blockchain and securities law in Alabama. 6. Document the process. Maintain thorough records of the analysis, assumptions, and conclusions.